I'm calling to order this meeting. I'm calling to order this meeting. This is a regular meeting of the Committee of the Whole of the Council of the District of Columbia. Today is Tuesday, November 21st, 2023. The time is 11:30 in the morning, and this meeting is being held in room 500, the council chambers of the John A. Wilson Building. Although it's possible that a member or two or three are participating virtually via the, I guess it's the Zoom video conference broadcast platform. This is a regular meeting. We have 7 measures for markup in the Committee of the Whole and 2 measures that are being agendized for the legislative meeting from other committees. Today's Committee of the Whole meeting will be followed by an additional legislative meeting of the council. We begin our committee meetings by determining whether there's a quorum. Mr. Cash, would you call the roll?
Chairman Mendelson.
Present.
Councilmember Allen.
Here.
Councilmember Bonds.
Here.
Councilmember Fruman. Present. Councilmember Gray. Councilmember Henderson. Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Councilmember Nadeau.
Here.
Councilmember Parker.
Here.
Councilmember Pinto.
Present.
Councilmember Robert White.
Present.
Councilmember Trahan White. Councilmember Trahan White. Mr. Chairman, you have a quorum.
Thank you, Mr. Cash. We have the filing of committee reports. Madam Secretary, Mr. Assistant Secretary, the log was circulated yesterday for the committee reports. I noted some omissions to the secretary. I don't know if it was corrected. Say that
Good
again.
morning, Mr. Chairman. No, unfortunately, they were not corrected. They will be included on the next log.
Okay. Recognize the Chair Pro Tem, who seems to be very busy at the moment, for a motion
Sure. I
on
move
the secretaries on the
report. Secretary's report.
on committees. Yes.
Thank you, Chairman. I move to waive the reading of the Secretary's report.
So the motion to waive the reading of the report. Is there discussion on the motion? Voice vote. All those in favor say aye.
Aye.
Are there any opposed? The ayes have it unanimously. We have the Secretary's log of introductions and referrals. I'm going to recognize the Chair Pro Tem.
I move to waive the reading of the Secretary's log of introductions and referrals.
It's been a motion to waive the reading of the Secretary's log of introductions and referrals. I have not discussed this with the Secretary or Assistant Secretary. There's no objection. I would like to add to the log this resolution, fiscal year 2025 budget submission requirements resolution of 2023. This is the standard resolution that we consider each fall. It sets the date, which I believe is March 20th, for submission of the budget by the mayor. It sets forth in detail over the course of 354 lines of text the requirements with the information that we want to receive with the budget submission. The intent is that this will be adopted by the council on either December 5th or December 19th. So we will file this in the Secretary's office today. The referral will be retained by the council, and we will file an abbreviated notice in the register so that this can be considered in less than 15 days. There's no objection. So that's added to the Secretary's log, fiscal year 2025 budget submission requirements resolution of 2023. With that, we have the motion before us, which is to waive the reading of the Secretary's log of introductions and referrals with this one measure added. All those in favor of the motion say aye.
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 Are there any opposed? The ayes have it unanimously. We have measures for consideration markup in the committee as a whole. I believe I said there's 7. The first is PR 25-409, entitled Commission on the Selection and Tenure of Administrative Law Judges of the Office of Administrative Hearings, Laura Hankins Appointment Resolution of 2023. The purpose of this resolution is to appoint, this is a council appointment, Ms. Laura Hankins as a voting member on the Commission on the Selection and Tenure of Administrative Law Judges of the Office of Administrative Hearings for a 3-year term to end April 30th, 2026. Laura Hankins is a Ward 4 resident of the District of Columbia and is currently General Counsel at the District of Columbia Public Defender Service. She received her Bachelor of Arts degree in Economics from Brown University and her Juris Doctor degree from Harvard University. She has spent the bulk of her legal career with the Public Defender Service, rising from a staff attorney to special counsel to the director, to her current position as general counsel. In 2001, the district established the Office of Administrative Hearings. Actually, the council, through legislation, established the Office of Administrative Hearings with the purpose of creating, quote, an independent agency to adjudicate administrative disputes, unquote, and to centralize the hearing functions currently handled by a variety of district agencies. The comprehensive administrative hearing system embodied in the Office of Administrative Hearings, also known as OAH, was created to address the need to modernize and improve administrative adjudication in the district so that citizens and persons doing business in the district will consistently receive high-quality, fair, impartial, and efficient hearings in administrative litigation. By developing innovative reforms for the District of Columbia's system of administrative justice, the OAH fosters public confidence and promotes higher levels of voluntary compliance that ensure better health, safety, and well-being in our community. The OAH decides contested cases involving more than 40 District of Columbia agencies, boards, and commissions. The OAH is led by a chief administrative law judge who is appointed to a 6-year term by the mayor with confirmation by the council. The Commission on the Selection and Tenure of Administrative Law Judges was established in 2001, concurrent with the establishment of the agency, and the commission is charged with the mission to, quote, ensure the recruitment and retention of a well-qualified, efficient, and effective core of administrative law judges, unquote, in the OAH. To fulfill this role, the commission appoints, reappoints, disciplines, and removes all administrative law judges. Let me see. The commission consists of 3 voting members, appointed 1 each by the mayor, the council, and the chief judge of the Superior Court. The voting members serve staggered 3-year terms, and they select among themselves the chairperson, who currently is Judge Robert Rigsby. This resolution was introduced by me on September 18th, 2023. The Committee of the Whole held a public roundtable on November 1st, and the committee received no testimony or comments in opposition to the resolution or the nomination for appointment. A reading from the report: based on her impressive credentials and dedication, and understanding of indigent litigants and dedication to public service, the committee recommends the appointment of Ms. Hankins to the commission for a term to expire April 30th, 2026. If there's no objection, move both the print and report with leave for staff to make technical, conforming, and editorial changes. Is there discussion?
Mr. Chairman,
Yes. Councilmember White.
I appreciate you moving this. I've had the great opportunity to work with Ms. Hankins in several capacities, both at the Office of the Attorney General and as a council member. She has always been just a consummate professional, which is not a surprise given her long and productive tenure at the DC Public Defender Service, but also her experience from the NAACP Legal Defense and Education Fund. You may have said this in your remarks, and I apologize if I missed it. I'm glad Ms. Hankins will have an opportunity to provide her wisdom and insights to the district. I did not catch when the term ends. How long is this term?
It's a 3-year term to end April 30th, 2026.
Thank you, Chairman.
Thank you. If there's no further discussion, the motion is on both the print and report with leave for staff. And we'll do a roll call, Mr. Cash.
Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The next measure for markup in the committee of the whole is PR 25-411. Again, this is a council appointment. District of Columbia Judicial Disabilities and Tenure Commission, Dr. Patrick Jackson, appointment resolution of 2023. The purpose of this PR 25-411 is to appoint Dr. Jackson as a member of the District of Columbia Judicial Disabilities and Tenure Commission for a 6-year term ending May 5th, 2029. The commission was established by Congress to discipline, retire, or remove judges on the Superior Court of the District of Columbia and the District of Columbia Court of Appeals. The commission has the authority to suspend a judge convicted of a felony under federal law or which would be a felony in the district. The commission may also remove a judge for willful misconduct in office, for willful and persistent failure to perform judicial duties, and for conduct prejudicial to the administration of justice or conduct which brings the judicial office into disrepute. The commission also has the authority to retire a judge involuntarily if the commission determines that the judge suffers from a mental or physical disability which is or is likely to become permanent and which prevents or seriously interferes with the proper performance of duties. In addition, the commission may, under appropriate circumstances, publicly censure or reprimand a judge. The commission consists of 7 members, 1 member appointed by the President of the United States, 2 members appointed by the mayor, one of whom must be a non-lawyer, 1 member appointed by the council who must be a non-lawyer, 1 appointed by the chief judge of the district court for the District of Columbia who must be an active or retired federal judge in the district, and 2 members appointed by the Board of Governors of the DC Bar. A member of the commission must be a U.S. citizen, a district resident for at least 90 days prior to appointment, and must not be an officer or employee of the legislative or executive branch of the United States or district government. All members are appointed for a 6-year term, except the president's appointee who serves a 5-year term. Dr. Patrick Jackson is a Ward 3 resident of the District of Columbia. Dr. Jackson received his Bachelor of Arts from Harvard University, his medical doctorate from Columbia University. After completing his medical internship at the Massachusetts General Hospital Department of Surgery in Boston, Dr. Jackson went on to complete his residency and a medical fellowship at Massachusetts General. Dr. Jackson currently is a professor of surgery and chief of division of surgery at Georgetown University Hospital, and also serves as MedStar Regional Residency Program Director at Georgetown University Hospital, Washington Hospital Center. Reading from the report, assuming we adopt this based on his credentials and commitment, the committee recommends the appointment of Dr. Jackson to the District of Columbia Commission on Judicial Disabilities and Tenure for a term to end May 5th, 2029. This resolution was introduced by me on September 18th, 2023. The Committee of the Whole held a public roundtable on the resolution on November 1st, 2023, and received no testimony or comments in opposition. Without objection, I'll move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? Councilmember Allen.
Thanks, Mr. Chairman. I just wanted to know, this is a often overlooked commission, but a really vital one. So I really appreciate that. I want to thank you for accepting my recommendation to nominate Dr. Jackson this position. I think his expertise is going to be a very significant addition to this commission. So appreciate that and are moving forward today.
Thank you. If there's no further discussion, we'll have a roll call. The vote is on both the print and report with leave for staff. Mr. Cash.
Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray. Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the agenda for the additional legislative meeting today. The next measure for markup is PR 25-480. Again, this is a council appointment. Board of Directors of the Washington Metropolitan Area Transit Authority, Valerie Joy Santos, appointment resolution of 2023. The purpose of PR 25-480 is to appoint Ms. Valerie Joy Santos as a principal member of the Board of Directors of the Washington Metropolitan Area Transit Authority for a 4-year term to end June 30th, 2027. Ms. Santos is a Ward 3 resident. She received her Bachelor of Arts degree from Santa Clara University, a Master of Public Policy degree from Harvard University's Kennedy School of Government, and a Master of Business Administration degree from the Harvard Business School. Currently, Ms. Santos is a Senior Urban Development Specialist at the World Bank. Prior to that, she was Deputy Mayor for Planning and Economic Development for the Government of the District of Columbia, serving from 2009 through 2010. Prior to her government service, Ms. Santos served as a Vice President at Jones Lang LaSalle, a global real estate services and investment management firm, where she specialized in public sector real estate. The Washington Metropolitan Area Transit Authority is a regional instrumentality that was created in 1967 through an interstate compact between the District of Columbia, the state of Maryland, and the Commonwealth of Virginia to plan, develop, finance, and operate a regional transportation system in the Washington metropolitan area. Pursuant to the compact, WMATA is governed by the WMATA Board. The purpose of the WMATA Board is not only to govern WMATA, but to develop policies and provide provide oversight for the management, maintenance, funding, and operation of the transportation system. The WMATA Board is comprised of 8 principal directors who are voting members and 8 alternate directors. The signatories to the compact each appoint 2 voting and 2 non-voting members. The members, both voting and non-voting, are appointed by the council. Obviously, that's us, the Washington Suburban Transit Commission, the Northern Virginia Transportation Commission, and the Secretary of the U.S. Department of Transportation. The law requires that to be eligible for appointment to serve on the Board of Directors, an individual shall have a demonstrated interest in public transportation and experience sufficient to represent the district well on the board. The committee report cited an earlier law that had a number of detailed requirements which are no longer required. Also, the committee report cites a term limits, and that was repealed by the council several years ago. During the committee's public roundtable on this measure, Ms. Santos emphasized the importance of transit-oriented development as a means of reducing waste and increasing revenue on WMATA-owned real estate. She suggested that her background in economic development would be important as WMATA contends with expected budget shortfalls in the coming fiscal years. Reading from the report, assuming this is adopted based on her interest, credentials, and her transit advocacy, the committee recommends the appointment of Ms. Santos to serve on the WMATA board for a four-year term to end June 30th, 2027. This measure was introduced by me on October 17th, 2023. The Committee of the Whole held a public roundtable on November 1st, 2023, received no testimony or comments in opposition. So if there's no objection, I move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion?
Mr. Chairman.
Mr. Chair.
Councilmember Henderson.
Thank you, Mr. Chairman. I don't have any opposition to Ms. Santos' nomination. I actually think that her background in real estate is quite helpful in terms of some of the joint developments that I know that WMATA is seeking to pursue at certain sites around the district. But I did have a question that didn't come up in her testimony nor in her resume, which is whether or not she regularly or semi-regularly actually uses Metro to get around the city. Not that that is a requirement, but I do think it's helpful.
I agree with you. She is an occasional user of Metro, both rail and bus.
Okay.
When I asked her about this, because our other regular nominee or not nominee, appointee uses the bus or rail every day. Ms. Santos said that I can't remember if it's one or two kids and driving them to school, that public transit doesn't work every day for her.
Understand. It doesn't work every day for lots of people, but to never use it and sit on the board, I think would be problematic.
Correct. No, she's not a never user.
Okay, great. Thank you.
Thank you. Anything else on this, Councilmember Allen?
Thank you, Mr. Chairman. First, I want to thank you for moving to fill this position. As many of us know, the seat had previously been filled by former Deputy Mayor Lucinda Babers, who resigned effective July 1st, 2023, which is more than 4 months ago. We are in the middle of an existential crisis when we think about our public transportation in the district, so we simply cannot let the district's second principal WMATA seat sit empty for long. I do want to thank Spring Worth, the district's alternate board member, for representing the council extremely well after Ms. Babers stepped down. And I'm glad the district will be fully represented at the next board meeting, which is coming up, because it's the next WMATA board meeting. That's a huge one. The board will get its first look at WMATA's proposed fiscal year 25 budget. In fact, the board will see more than one proposed budget. Given that the district and our neighboring states have not yet approved additional funding, WMATA is in the position to have to propose a doomsday budget based on the $750 million deficit that it's facing next year, as well as at least one other proposed budget on possible actions by the charter member states to increase our dedicated funding. I've worked with Ms. Santos for a long time, dating back more than a decade. I know her to be a smart, dedicated public servant, as well as an expert in economic development and local finance, which I think is going to be invaluable expertise over the next coming months and years. And of course, as we just talked about, she does ride transit, and I expect we'll see her become a more regular transit rider as well. I know I'm looking forward to working closely with Ms. Santos and with our other board member, Tracy Hayden Lowe, as we have to fulfill our commitment to fully fund our regional public transportation system. And I know that Ms. Santos is, and all the rest of us are, up to that task that we have over the next couple of months and in the year to come. Thank you, Mr. Chairman.
Thank you, Councilmember Allen. Councilmember Robert White.
Thank you, Chairman. I want to thank you for moving this nomination forward in what is such a critical time for WMATA charting a course for the future. As the Councilmember Allen just articulated, I had the opportunity to work with Ms. Santos when she was deputy mayor. I was legislative counsel to Congresswoman Norton and handled district issues. I have always found her to be sharp, to understand the district really well in a time where WMATA is going to have to make some very difficult choices. I am happy to know that we are likely to have someone on the board who understands the district, who understands our needs, who understands transit-oriented development, and has some experience dealing with significant budgets, even during challenging times. So I think Valerie Joy Santos will be an excellent addition to the WMATA board, particularly at a time where we need some experienced folks representing our district residents. Thank you, Chairman.
Thank you, Councilmember. Anything further, or if there is no further discussion? The vote will be on both the print and report with leave for staff. And again, I noted an error in the report, which will be fixed. Mr. Cash, would you call the roll?
Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The resolution, the print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
And Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. If there's no objection, I'm going to move the next two resolutions together. That's PR 25-410, District of Columbia Corrections Information Council Governing Board, Catherine Aiken Huffman, reappointment resolution of 2023, and PR 25-412, Corrections Information Council Governing Board, and Nkechi Taifa, reappointment resolution of 2023. These are both reappointments. They are council appointments to the Corrections Information Council Governing Board. The Corrections Information Council was created by Congress in 1997 as part of the Revitalization and Self-Government Improvement Act. The purpose is to investigate generally the conditions of the District of Columbia sentenced felon population scattered throughout the Bureau of Prisons facilities following the closing of the Lorton Correctional Complex. The Correction Information Council's role was expanded by the Jail Improvement Act of 2003, which requires the CIC, Corrections Information Council, to conduct inspections of local correctional facilities and mandates that the Department of Corrections provide access to members of the CIC. In 2010, the council amended the law and restructured the CIC by creating the board and an independent executive director position and provided subordinate personnel. The 2010 Act vested in the executive director several responsibilities that had been with the appointed members prior to the 2010 amendments. The executive director acts as the investigator as well as ombudsman, looking at conditions, responding to complaints, and making recommendations to the board. The role of the board is to provide advice and information to the director of the Bureau of Prisons and to the director of the Department of Corrections regarding matters affecting District of Columbia inmates. In addition, the board is tasked with reviewing the findings of the executive director and making recommendations where appropriate regarding the conditions of confinement of District of Columbia inmates in the Federal Bureau of Prisons or the DC Department of Corrections. The board is also tasked with giving final approval of the executive director's annual report to the director of the Bureau of Prisons and the director of the Department of Corrections. The board consists of 5 members, 3 appointed by the mayor and 2 by the council. The mayor designates the chair of the board. The board members serve for 2-year terms, and they all serve without confirmation. Catherine Huffman, that's PR 25-410, was first appointed to the board in May of 2012. And Ms. Taifa, I have that here. I don't see it readily, but this is a reappointment, so she has been on the CIC for a number of years. I believe that there are 3 other resolutions pending in the Committee on Judiciary and Public Safety that were introduced by the mayor. Just so everyone is clear, council appointments come through the Committee of the Whole, and the other appointments from the mayor, nominations to the mayor, go through the appropriate subject matter committee. Catherine Huffman is a Ward 3 resident, received a Bachelor of Arts degree in psychology from Emory, Juris Doctorate from Yale. After completing her law degree, she clerked for the Federal Sixth Circuit and Um. That's an incomplete sentence. In any event, she's been quite involved in the field of corrections for a number of years. Ms. Taifa is a Ward 4 resident. Received a Bachelor of Arts from Howard, Juris Doctorate from George Washington University Law School. She has served as a staff attorney for the National Prison Project of the ACLU Foundation. Also served as public policy counsel for the Women's Legal Defense Fund, legislative counsel for the American Civil Liberties Union, and as an adjunct professor at American University. And the report gives other experience. Both of these resolutions were introduced by me. Well, actually, Ms. Huffman on this September 18th and Ms. Taifa on September 19th. The Committee of the Whole held a roundtable on both of these nominations on November 1st, 2023, and the committees received no testimony or comments in opposition to either nominee. Again, without objection, I move both the prints and reports for both PR 25-410 and 25-412 with leave for staff to make technical conforming and editorial changes. Discussion. Mr. Cash, would you call the roll?
Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The two resolutions to prints and reports are approved unanimously. Madam General Counsel, are these two measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Once the reports and hearing records are filed.
Madam Budget Director, do the measures fiscal impact statements comply with council requirements?
Yes, they do.
Without objection, these measures will be placed on the consent agenda for today's additional legislative meeting. The next measure for markup is PR 25-444, Child Support Guideline Commission, Maridel Boulevou, reappointment resolution of 2023. Again, this is a council appointment. And it's actually a reappointment. The the purpose of PR 25-444 is to reappoint Ms. Boulevou as a member of the Child Support Guideline Commission for a 4-year term ending December 20th, 2026. The commission consists of 9 members, all of whom must be district residents. The mayor shall appoint the chairperson as well as 2 members, one of whom must be a member of the DC Bar and an expert in the fields of family law and child support. The mayor must also appoint 1 member to represent the Child Support Enforcement Division of the Office of the Attorney General. The chief judge of the Superior Court may appoint 2 members. The council shall designate 1 council member, which we did by resolution, I think at our last meeting, and appoint 2 additional members. One of the 2 members shall be a member of the DC Bar and an expert in the fields of family law and child support. Ms. Boulevou is a Ward 3 resident. She received a Bachelor of Arts from Princeton, a Juris Doctorate from Georgetown University Law Center. Currently, she is employed as a supervising attorney in the Domestic Violence and Family Unit at the Legal Aid Society of the District of Columbia. As a supervising attorney, she represents low-income clients in child custody and child protection order cases and custodial and non-custodial parents in child support and paternity cases. She also mentors pro bono attorneys in family law. The Child Support Guideline Commission examines the child support guidelines and makes recommendations to the mayor. Under district law, any case involving the establishment of child support or modification of an existing child support order requires a judicial officer to conduct a hearing and make a finding in accordance with the child support guidelines. The child support guidelines provide a presumptive formula for determining the amount of child support in cases where the parents are unmarried, separated, or divorced. Ms. Boulavoux will continue to serve as the family law and child support expert as required in the code. She meets those requirements. And reading from the report, assuming this is approved, based on her significant contributions to the Child Support Guideline Commission and her impressive credentials and commitment, the committee recommends the reappointment of Ms. Boulavoux to the commission for a term to end December 20th, 2026. This resolution was introduced by me on September 26, 2023. The committee of the whole held a public roundtable on November 1st, 2023. And the committee has received no testimony or comments in opposition to the appointment. Objection, I move both the print and report with leave for staff to make technical, conforming, and editorial changes. Discussion. Mr. Cash, would you call the roll?
Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Secretary, is the record complete?
Once the report and hearing record are filed.
And Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. The last measure for markup in the committee of the whole is actually not a council appointment. It is a confirmation of a mayoral nomination, and that's PR 25-486, Board of Zoning Adjustment Carl Blake Confirmation Resolution of 2023. The purpose of this resolution is to confirm the reappointment, the mayor's nomination for reappointment of Carl Blake as a member of the Board of Zoning Adjustment for a term to expire September 30th, 2025. The Board of Zoning Adjustment is a creation of federal law. It's composed of a member of the National Capital Planning Commission or NCPC staff member, a rotating member of the Zoning Commission, and 3 members appointed by the mayor with the advice and consent of the council. Of the 3 members appointed by the mayor, each must have been a resident of the District of Columbia for at least 3 years immediately preceding his or her appointment, and at least one of those 3 members must own his or her own home. The Board of Zoning Adjustment is authorized to consider applications for special exceptions and variances, as well as to hear appeals from decisions granting or refusing a building permit or granting or withholding a certificate of occupancy, or appeals from other administrative decisions based on the zoning regulations or zoning map. Mr. Carl Blake is a financial services professional and has been a resident of the district since 2003. He currently is a Ward 4 resident and owns his residence. In addition, he owns a number of other residential investment properties throughout the district. He is Director of Financial Planning for Blue Water Group, Inc., a risk management and financial consulting firm focusing on public and private utilities. And he's also founder of Blake Properties Net LLC, a real estate investment management and financial services consulting firm. The firm manages a portfolio of rental properties, including mid-income, single-family and multifamily properties throughout the district, New York, New Jersey, and North Carolina. Let me see. Assuming that this is approved by the committee believes that Mr. Blake has developed expertise in this field and that he has been a collaborative member of this important board. And therefore, the committee recommends the confirmation of Mr. Carl Blake for reappointment as a member of the Board of Zoning Adjustment for a term to expire on September 30th, 2025. Without objection, I move both the print and report with leave for staff to make technical conforming and editorial changes. Is there discussion? Mr. Cash, would you call the roll?
Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Mr. Cash. The print and report are approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. That completes items for markup in the committee, by the committee. We have two measures from the Committee on Housing chaired by Councilmember Robert White. The first is PR 25-448, Chief Tenant Advocate of the Office of the Tenant Advocate, Johanna Shreve, confirmation resolution of 2023. Mr. White.
Thank you, Chairman. PR 25-448 would reappoint Chief Tenant Advocate Johanna Shreve for a new 3-year term to end June 3rd, 2026. This resolution was introduced by you, Chairman Mendelson, at the request of the mayor on September 29th. The committee held a roundtable on this resolution on Thursday, November 2nd, and the committee marked it up unanimously on November 9th. Johanna Shreve had already been serving in a holdover capacity for some time before the resolution reappointing her was introduced. Ms. Shreve has been a champion for tenants in the district since she originally created the Office of the Tenant Advocate as a temporary division within the Department of Consumer and Regulatory Affairs in 2006. She continued to lead the office when it became independent in 2007, and OTA has never had another chief tenant advocate. Throughout her tenure, OTA has only grown, becoming a respected voice for tenants at the council and throughout the city. Ms. Shreve's advocacy has had wide-ranging impacts, from helping create a tenant bill of rights to lease reform, supporting elderly tenants with tenants with disabilities, and safeguarding tenants through the pandemic. Ms. Shreve's career started with the National Corporation for Housing Partnership in 1978. She has also worked at DC Public Housing, the National Association of Home Builders, and her own consulting firm on housing policy. Given my experience working with Ms. Shreve, I support her reappointment as Chief Tenant Advocate. I look forward to working with her as she implements her vision for the future of OTA over the next 3 years. Thank you, Chairman. I move PR 25-448 and request that it be placed on the consent agenda of the legislative meeting later today.
Thank you, Councilmember White. Are there questions from members? Councilmember Louis George.
I wanted to note that Ms. Shreve has done an outstanding job leading the Office of the Tenant Advocate. Her and her office have been extremely responsive to the needs of Ward 4 residents and tenants when issues have arisen. Given the housing crisis and the rent crisis we have in the city, they have had to work a lot with a little. My hope is that when we go into budget next year, we take into account the work and the amount of work that the Office of Tenant Advocate under Shreve's leadership has to take on and what that may look like in the future. But I think I support this reappointment, and I thank Ms. Shreve for being willing to serve further despite all that they have to endure with housing in this city. Councilmember Robert White, wouldn't you agree?
I would.
Thank you, Councilmember. Anything further in terms of questions? Well, I have three questions. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's additional legislative meeting. Councilmember Robert White, you have the next measure, PR 25-449, Rent Administrator Lauren Pear, Confirmation Resolution of 2023.
Thank you, Chairman. Proposed resolution 25-449 would confirm the reappointment of Lauren Pear as rent administrator. Under district law, this nominating resolution would be deemed approved on January 11th, 2024 without council action. The Committee on Housing unanimously supported Ms. Pear's nomination, and I encourage my council colleagues to do the same today. The rent administrator leads the rental accommodations division within the Department of Housing and Community Development and is responsible for implementing the Rental Housing Act of 1985. Under the rent administrator's leadership, the division is tasked with protecting tenants from rising housing costs, creating and preserving affordable rental housing, and managing systems to resolve disputes between housing providers and tenants. The division also carries out the district's rent stabilization or rent control program. This work includes standing up a publicly accessible rent control database, which the division has been working on for years. Because there was confusion earlier this year, I want to clarify that the rent administrator does not have the authority to depart from the law or maximum rent increases for rent stabilized housing. The mayor and council first appointed Lauren Pear as rent administrator in 2017. Ms. Pear is a native Washingtonian and Ward 4 resident. She holds a master's in public administration and a law degree, and she is licensed to practice law in the district, Maryland, and before the Supreme Court. Ms. Pear's work history shows a demonstrated commitment to public service and housing regulation. Prior to DHCD, she worked as a judicial law clerk and as a commercial real estate attorney. Beginning in 2006, Ms. Pear joined DHCD as the rent conversion and sale administrator. She also served a one-year term as DHCD's interim inclusionary zoning program manager. Through these roles, Ms. Pear gained experience investigating claims and disputes, advising the executive on technical rent control matters, and initiating enforcement actions. If reappointed, Ms. Pear plans to strengthen the division's relationship with sister agencies and to complete her division's work on the rent control database. Ms. Pear has effectively led the rental accommodations division at DHCD for 6 years. Her expertise will continue to serve the district's renters and housing providers well, and I look forward to moving this resolution today. Thank you, Chairman.
Thank you, Councilmember. Are there questions from members? Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
The objection, this measure will be placed on the consent agenda for today's additional legislative meeting. That's going to complete all the business items for this committee of the whole meeting. I want to remind members that the budget submission resolution has been introduced and members are encouraged to look at it. Well, maybe not encouraged, but welcome to look at it. And because this is what sets forth what information the executive and the CFO are required to provide when we get the budget, as well as sets the date. If any member has comments on this or suggestions, edits, whatever, please work with the budget director. Even though I introduced this is any amendments will go through the budget director's office. Well, maybe me, but through the budget director. So, and do please feel free to talk to the budget office about this. With that, the time is 12:20 and, we will start in how many minutes? 5. We will start at 12:25. The meeting, it's 12:20 PM. This meeting's adjourned. Um,
Mr.
Okay.
Chairman, there is no after-school care for DCPS today. So if we can move this right along.
I'm calling to order this meeting. This is an additional legislative meeting of the Council of the District of Columbia. Today is Tuesday, November 21st, 2023. The time is 12:21 in the afternoon. This meeting is being held in room 500 of the council chambers of the John A. Wilson Building, although there's several members who are participating virtually. We always begin our legislative meetings with a moment of silence. If everyone in the chamber, and actually everyone participating virtually, would respect a moment of silence, please. Madam Secretary, would you call the roll?
Councilmember Allen,
I'm here.
Councilmember Bonds, here. Councilmember Freeman,
Present.
Councilmember Gray, Councilmember Henderson,
Here.
Councilmember Lewis George. Here. Councilmember McDuffie,
Here.
Chairman Mendelson,
Present.
Councilmember Nadeau,
Here.
Councilmember Parker,
Here.
Councilmember Pinto,
Present.
Councilmember Robert White,
Present.
Councilmember Trayon White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. We have the consent agenda, which includes 2 ceremonials, all of the appointment resolutions that came through the Committee of the Whole, the temporary bills from the last council meeting. Are there any changes to the consent agenda? I don't hear any changes. Should note the temporary bills are final reading. We'll have a roll call vote on the consent agenda, and there are no changes to it. Madam Secretary?
Councilmember Nadeau, Councilmember Nadeau,
Yes.
Councilmember Parker,
Yes.
Councilmember Pinto,
Yes.
Councilmember Robert White,
Yes.
Councilmember Trayon White,
Yes.
Councilmember Allen,
Yes.
Councilmember Bonds, yes. Councilmember Freeman,
Yes.
Councilmember Gray,
Yes.
Councilmember Henderson,
Yes.
Councilmember Lewis George,
Yes.
Councilmember McDuffie,
Yes.
Chairman Mendelson.
Yes.
Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The consent agenda is approved unanimously. We have the non-consent agenda. The first measure is the opioid crisis and juvenile crime public emergencies extension authorization. First is the declaration PR 25-536. Councilmember Pinto.
Thank you, Mr. Chairman. Today, along with Councilmembers Henderson and Councilmember Trayon White, I am moving the opioid crisis and juvenile crime public emergencies extension authorization emergency amendment act of 2023. On November 13th, 2023, the mayor issued order 2023-141, which declares 2 separate public emergencies in the district related to the ongoing opioid crisis and the ongoing crisis of youth violence in the district. The emergency declaration allows district agencies to respond more flexibly, cooperatively, and expeditiously to these crises. First, regarding the opioid emergency, as the council has formally recognized, opioids have inflicted profound harm on communities within the district and across the nation. Between January and July of 2023, we've averaged 42 opioid fatalities every month. The mayor's order addresses this crisis by improving information sharing so we can more quickly identify communities heavily affected by opioid-linked fatalities and better provide services and care to those communities. Second, regarding the youth crime emergency, the district is experiencing an increase in violent crime, including very concerning trends among our youth. In the first 9 months of 2023, there were 458 arrests of juveniles for robbery, including carjacking, homicide, or assault with a dangerous weapon, a number which is already 10% more than the total number of such arrests in all of 2022. The number of district youth victimized by violent crime has also increased significantly. The mayor's order aims to improve our response to this crisis. We have seen an increasing population at the Department of Youth Rehabilitation Services, or DYRS, in recent months, and we know that overcrowding at DYRS leads to worse outcomes. It's critical that we take steps to ensure that our youth rehabilitation system is doing what it is intended to do, which is to rehabilitate our kids. To address this, the mayor's order contains a number of directives to DYRS and other agencies aimed at, among other things, improving our capacity at DYRS. Both of these crises require urgent action, and it's important that the mayor be authorized to extend her order so that district agencies can respond appropriately. Under district law, however, a public emergency declaration may not extend beyond 15 days without council authorization. This legislation authorizes the mayor to extend these emergencies until March 31st, 2024. I'll note that we made one change to the bill after its initial circulation last week. The bill now requires that the executive provide written notice to the council prior to the exercise of the authority granted by the Emergency Act. I am first moving an amendment to the emergency declaration resolution. This amendment makes some minor technical edits, including to statistics on youth carjackings in the district this year. I move the amendment.
Thank you, Councilmember Pinto. So we have before us the declaration, and Councilmember Pinto's moved that and then moved an amendment to it. The amendment was circulated this morning, I believe, at 11:26 a.m.
Yes.
That sound right?
Yes.
And the amendment says subsection A of section 3. Subsection A is amended to read as follows, and then subsection D is amended by changing some language.
That is the deck.
Yes, the declaration. Does anybody need that better explained, or are we fine with the amendment? And I'll just ask if there's no objection, it will be accepted. Let's try, if there's no objection, the amendment will be accepted. Hearing no objection, the amendment is accepted. We have the declaration as amended. Discussion,
Mr. Chairman.
Councilmember Henderson.
Thank you, Mr. Chairman. As many of you know, the Committee on Health has been incredibly focused on the opioid crisis in the district this past year, holding multiple hearings. On November 7th, the council unanimously voted to approve PR 25-386, the sense of the council on the opioid and fentanyl epidemic resolution of 2023. The measure urged the mayor to declare the opioid and fentanyl crisis in the district as a public health emergency, recognizing the seriousness of the situation and committing sufficient resources to safeguard the well-being of district residents. The following week, the mayor did issue a mayor's order that declared two separate public emergencies, one related to the ongoing opioid crisis and another related to juvenile crime. I'm going to focus most of my comments on opioids as Councilmember Pinto covered the juvenile portion. As of October 2023, there have been a total of 296 opioid-related fatal overdoses in the district. The city is on track to experience an increase from 2022, which was 461. Alarmingly, more than 90% of the opioid-related fatal overdoses in the past 3 years were linked to fentanyl or its analogs. We've had even more non-fatal overdoses over calls or suspected cases of non-fatal overdoses in the district as well. We need a major shift in this trend. The mayor's order is a critical step towards more effectively responding to this crisis. In times of emergency, swift and coordinated action is paramount. One key aspect of the mayor's order for this particular portion involves enhancing data sharing between vital agencies, the Department of Behavioral Health, DC Health, Fire and Emergency Medical Services, and the Office of the Chief Medical Examiner. This collaborative effort ensures real-time information on non-fatal overdoses, enabling us to deploy outreach teams more strategically. With up-to-date data, outreach teams can swiftly be directed to overdose hotspots in impacted areas. Their primary focus will be on providing harm reduction supports and services to those most in need, contributing to a more proactive and impactful response. Additionally, the mayor's order includes an expedited procurement process. This streamlined approach is designed to empower the Department of Behavioral Health and other related agencies to rapidly allocate funds for initiatives, programs, or other goods. As a reminder for my colleagues and for the public, the district currently has approximately $14 million in opioid settlement funds that are currently available for investments in community. The agility provided through this public emergency is crucial in making substantial impact on the crisis. I want to thank the mayor for moving on this effort, and I look forward to continuous work in this area. Thank you.
Thank you, Councilmember Henderson. Further on the declaration. We'll have a roll call vote on the declaration. The declaration was amended without objection with Councilmember Pinto's amendment. Madam Secretary, would you call the roll? This is on the declaration.
Councilmember Parker,
Yes.
Councilmember Parker votes yes. Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White,
Yes.
Councilmember Trayon White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
yes,
Councilmember Bonds votes yes. Councilmember Fruman,
Yes.
Councilmember Fruman votes yes. Councilmember Gray,
yes,
Councilmember Gray votes yes. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes, and Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration as amended is approved unanimously. We have the underlying bill, Bill 25-579. Councilmember Pinto.
Thank you, Mr. Chairman. I move amendment number 1 to the Emergency Act. This amendment makes one change. The mayor's order invokes broad authority for the executive to waive district laws to respond to the emergencies declared by the order. The bill that we filed yesterday granted a more limited set of authority, and the intent was to avoid giving blanket authority to waive laws without knowing precisely which laws we were giving authority to waive. We tried to work with the administration over the weekend to understand which laws specifically they need to waive in the short term to accomplish the things that they're trying to do here. However, the administration was not able to provide this list. With the choice of being overly restrictive or not acting was not a good choice to move forward, as I believe we need to act in accordance with the true emergency that we are in. I do believe it's important for the administration to be able to act with this urgency here. And because of that, this amendment removes language seeking to specify the laws that may be waived, reverting to the language in the originally introduced bill, simply allow the mayor to extend the emergency orders for a determined amount of time, which is also why we included language to provide notification to the council about which laws are being waived. We can always revisit this when we have a clearer picture of which laws must be waived, and I hope that the administration will work openly with us on this, so in the future, we can limit the authority to those laws that must be waived specifically. This is about transparency and good government, and I hope that we can come back to revisit this with true cooperation and collaboration. I do want to note, Chairman, I'm going to have one additional technical edit that I'd like to move by oral amendment after we vote on this amendment. I move the amendment.
Thank you, Councilmember Pinto. So the amendment was circulated together with the amendment to the declaration at around 11:26 this morning.
Right.
It strikes lines 43 through 49 of the bill. That's the substance of it. Maybe I will speak first. I usually speak last. I'm not comfortable with this amendment at all. In fact, I'm not going to support this amendment. I have heard nothing but concern from lawyers all over the place for the last 6 days with regard to the mayor's interpretation of flexibility. And I'll start with this. The mayor's order, which can only be in effect for something like 15 days, which is why we have this legislation, so that the public emergency can be extended. The law only allows her to do this for 15 days, but her order says in it on page 5, district agencies may, without regard to established operating procedures, enter into contracts, et cetera, including reprogramming. And it's clear that what the mayor or the executive office of the mayor or her top officials have intended is that council review of contracts and reprogramming, both of which are requirements of the Home Rule Act, could be waived by this order. My understanding is it's still their interpretation that the language without regard to established operating procedures is very broad and it could apply to a whole range of laws. And I would say by precedent, this is not what we did with the public health emergency for 2 years with COVID. We were quite explicit with regard to what could be waived. And it's concerning to me that when the mayor or the executive office of the mayor was asked to, well, tell us what laws you want to waive, that we couldn't get a list. I believe that's what my Ward 2 colleague said, that we couldn't get a list. So I think the language that's in the bill as filed, notwithstanding the law, the mayor shall comply with all district laws when exercising her authority, except that the mayor may waive the requirements of Title IV of the Procurement Practices Reform Act. So that gives her quite a bit of flexibility with regard to procurement. And that's been our practice with emergencies in the past. If she needs explicit authority with regard to other laws, let her be explicit. And we'll probably give her that, but she should be explicit. So I won't be supporting this amendment. Further on this? Councilmember White?
Thank you, Chairman. I'll say a little bit more when I offer an amendment, but I appreciate your thoughts, Chairman. Declaring an emergency is a tool. It is not a plan. So the council here is taking action by declaring dual emergencies. We're giving the mayor expansive powers to act, but we still don't have a plan. Even looking at the mayor's order, I'm seeing data gathering and procuring beds. I don't see anything in the order that actually requires an emergency. We could have started procuring beds a month ago, 2 months ago. Collecting data on opioids could have started some time ago, and I don't think requires an emergency. I am concerned that we are so far into these crises and we don't have a plan. We don't seem to be able to get information from the mayor on which laws she wants to waive. And we understand from the discussion last time we met that the powers granted to the mayor under an emergency are expansive. They include procurement. They include rationing things like food and gasoline, acquiring property, arresting people. They are expansive. So a blank check with no indication of a plan makes me very nervous. I appreciated the proposal Councilmember Pinto put forward. I believe it was yesterday. I'm concerned about pulling that back. I plan to vote no on this amendment. Thank you, Chairman.
Thank you, Councilmember. Further discussion? We have I see activity at the far end.
Mr.
Mr.
Chairman,
Parker,
I have a question of Councilmember Pinto.
please.
Mr. Chairman, if you could seek to get an answer to or clarification around the timeline provided in getting the details that Councilmember Pinto requested of the executive. It sounded like the request was made. The executive did not return the information, but I'm curious if there's a timeline that was provided of giving said information.
Councilmember Pinto, when did you start working with the executive on this?
Last week, and on Saturday, I asked for a list of specific laws that needed to be waived, or on Friday. There is not a specific timeline that they gave that they would have this information. I would say, I think that it is certainly preferable to have a list of statutes that we're going to waive. But in the absence of that, if we all are saying, which I believe we are, that there is an emergency with opioids and with juvenile crime and violence, we have to move forward, I believe, in a way that allows the executive to move quickly. And that does not mean that we shouldn't come back to this to revisit once we have that list of additional laws that we need. We could always do that in 2 weeks. That's also why we included the notification requirement to say that before waiving any laws, notice has to be given to the council, which will also allow us to develop our own list of laws that are going to be fundamental here as we move forward to addressing these crises. But I think we have to ask ourselves, is this an emergency? We declared 2 weeks ago that there was an opioid emergency. We declared several minutes ago that there were 2 emergencies in opioids and juvenile crime. And I think in order to ensure that that means something, we have to extend authority for the mayor to act quickly and to address these crises. And so I do not think today is the end of the conversation, but I don't want the fact that we don't yet have that full list to inhibit our ability of moving forward. And we will see more lives lost and we'll see less action than we could have today. So it's not perfect. It's not my ideal either, but I think it is the best path forward.
Mr. Chairman, one quick follow-up question, if I might.
Yeah, although I have an answer as well. Our general counsel reached out on Friday to ask for what laws they were looking at. And so I think what's at work here is that they want the broadest flexibility they can possibly construe. And we've been through this before with the public health emergency, as I noted. And I would add there's a sort of an analog to when the council went on recess. I think it was in 2021, because of the pandemic and the public health emergency, the executive wanted authority to proceed with contracts on an expedited basis with the minimal list of council review. And we said, give us a list of the contracts, and they just want the flexibility. And it was very hard to get that list. And the list was like, if I remember correctly, hundreds of contracts. And that was like, no.
Understood. I would just quickly note that without giving a timeline, and it doesn't seem like a timeline was given to Councilmember Pinto or the council at
You mean a
large.
deadline for their response?
Well, we've asked for information. They haven't given the information. I was asking that they at least give a timeline, and it doesn't sound like there's a timeline either, which is what I'm
Correct.
getting at is I don't think there is a plan to get us any more information. And instead there's this request for an overarching authority. But I just want to clarify for those that may be watching that voting against this adjustment to the amendment still allows for the emergency to go forward with special powers for procurement. And so it's not as though the council is saying there is no emergency and we're not moving forward. But I do share some of your concerns that just waving a magic wand and saying the mayor should have all power here without more information provided is pretty dangerous. And so the council has a job to do. I trust the mayor's good intent here, and I hope that the mayor's team can follow up with more information. Thank you.
Who is next in line? Councilmember Henderson and then Fruman. Councilmember Freeman.
So maybe it's a question for Councilmember Pinto, but just to make sure that I understand, I mean, the suggestion was made that we could add the specific list of laws that were waived in 2 weeks at the December 5th hearing or legislative meeting. Am I right that we could have the more limited extension of power without including the amendment and then amend again, come back in 2 weeks with the list?
Is that of,
That was a question to Councilmember Pinto. I mean, it seems to me obviously that is the case.
Yeah,
If that's,
sorry, go ahead.
yeah, you go ahead.
That is certainly possible. I would just say, let's remember what we are fighting for here. We want to ensure that the executive can act quickly. It's not over dramatic to say people are dying as a result of inaction. And so I would rather err on the side of being more broad so that she can act with deliberate speed to address this, to make sure that we don't have overcrowding at DYRS. She can contract for safe houses, for example, and shelter houses. That is an emergency today. We need that ability today. And so I would rather then continue to work with everybody and with the executive on trying to figure out what that list of statutes that need to be waived, as opposed to waiting indefinitely for a list and not acting in a way that's, I think, going to undermine our goals to make progress on these 2 emergency areas.
But I mean, it isn't that we wouldn't be giving any power to the executive. We'd be giving broad powers to the executive, presumably that would enable them to do that in the coming weeks. And it feels like it's an interesting dynamic because we urge them to declare an emergency. Then they declared an emergency that we worry is overbroad. And so we are, a little on a back foot, but we want to do this right. We want to do this in a way that's responsible. And so it isn't licensed for a, unlimited waiver. We should be working together to come up with what are those things that need to be waived in order for them to get the job done. But presumably waiving the procurement requirements enables them to do the key thing that you were talking about.
Mr. Chairman, can I just respond briefly to that?
if it wasn't a question, no, but I'll come back to you. Any further? Looks like Councilmember Henderson wants to be recognized.
Thank you, Mr. Chairman. I can appreciate my colleagues' concerns, particularly colleagues who were here during the public health emergency in terms of the broad powers. I think there was some back and forth amongst staff this weekend in terms of just trying to get an outline of what are the additional laws, especially given that at least as it pertains to, as it pertains to both emergencies, there seemed to be some desire for expedited procurement, one for shelter space, and then also for expedited procurement in order to move on some of the opioid settlement funds that are available. It has been alluded that there are other things, but it sounds as though we have not received clarity on that front. That being said, I don't want this debate to be misconstrued in terms of saying that the council is not serious about an emergency, that the council is not serious about this particular issue, or excuse me, either issue on that front. I'm not sure, Councilmember Pinto, as you are the introducer of this amendment, how you want to proceed. But just in terms of conversations with colleagues here, perhaps this is something that we can try again in December, given the executive more time for us to continue to collaborate on what additional is needed beyond procurement. Thank you.
Thank you, Councilmember Henderson. Councilmember
Chairman.
Councilmember Allen's next, and then you, Councilmember Bonds.
Thanks, Mr. Chairman. trying to follow the little back and forth here. I wanted to try to clarify one thing. Because what I heard in the discussion just a moment ago was, I mean, let's just be very honest. We've got a urgent need for the past several weeks. We have watched at the YSC, DWRS capacity has gone over its official capacity numerous times. That creates a dangerous scenario for the staff, for the young people. It doesn't serve them well to be rehabilitated. And so I think there is a clear and pressing need to be able to move towards the procurement for additional secure bed space. My understanding, though, is the emergency that's in front of us, absent of the amendment that's in front of us, the underlying emergency, specifically and explicitly allows for the mayor to have contracting and procurement authority to increase those secure bed spaces. Is that correct, Mr. Chairman?
I missed the very last part of it, but the language that would be struck, is explicitly exempts Title IV. Meaning that we're waiving, the mayor doesn't have to comply with Title IV of the Procurement Practice Reform Act, which is the competitive bidding requirement.
And the
So
effect of that would allow the mayor
to move more quickly.
maximum flexibility
Yes,
to be able to exercise their powers.
yes.
Okay. I think that's counter to what I heard a moment ago. So I just want to make sure that was very clear for the record, that that is explicitly part of what this legislation will allow.
Yes, and my understanding is that this is exactly what we did with the pandemic public health emergencies, was that the competitive requirement for procurements was waived.
Okay. I am reminded of just, I guess, about 2 weeks ago, when it was implored that we just need to work in, if we could just find a way to work in partnership. And I feel like I'm seeing everybody on this dais desperately want to work in partnership to help solve a problem.
Partnership with each other or partnership with the executive?
I'm going to say all the above. But partnership, as I said a couple of weeks ago, it's a two-way street. If there has been a request by this council to say, what specific laws do you need help exempting from? How do we help make sure you can move quickly? And there's just no response to that. I find that troubling and concerning while we're trying to grant emergency powers and trying to allow emergency actions that we all agree need to be taken, can be taken. I was struck by my colleague who talked about a plan that is needed, because that is desperately needed as well. Thank you, Mr. Chairman.
Let me clarify. My understanding is it's not like our general counsel or attorneys on staff reached out and there was silence and crickets. It's that the request was made, Councilmember Pinto said on Saturday, I know our general counsel on Friday, give us a list. And they did not give us a list. Councilmember Bonds.
Thank you, Chairman. I just wanted to add voice to this discussion and to let my colleague, Councilmember Pinto, know that I will be supporting her proposal. I think that when we continue to debate these matters, we're really wasting very precious time. I really do feel that way. We know what the mayor's order says. We know what Title IV says. And it just seems to me we're at a point where we either are supportive of giving or extending the privileges that are necessary at this time or not. Thank you, Chairman.
Thank you, Councilmember Bonds. Councilmember McDuffie.
Just briefly, I understand that there's another amendment that's going to be offered. I'm not sure where Councilmember Pinto is on that amendment, but it might be useful to hear it, because as I contemplate whether or not to support the amendment that's before us at this moment, I share concerns about not having the appropriate constraints on a public emergency. On the other hand, I would be more willing to support the existing amendment if there were some constraints on the amount of time the mayor had before the council would have to review it again. In other words, if it's possible to look at how long we're granting this authority, perhaps I would be amenable, I'm not sure if any colleagues would, to supporting Councilmember Pinto's amendment that gives the mayor a little bit more flexibility to be able to address what I think we all agree is a public emergency around the opioid crisis and juvenile crime. There's no disagreement there. I do share some of the concerns that have been raised, but I would be with the chair of the Judiciary Committee on allowing more flexibility given the serious crisis that we're facing right now. So if there were some constraints, if maybe we can hear the amendment that's coming up next.
Does anyone want to volunteer?
I have a technical oral amendment, just to get that out of the way, perhaps briefly. Or why don't I wait and Councilmember White, if you want to present your amendment, that's okay with me to kind of pause on this discussion for a moment.
I'm not in the business of outing anybody with regard to amendments. So, and there might be some strategic thinking behind what everyone's saying about amendments. So kind of leave it at that.
Mr. Chairman, may I speak on the current amendment?
Just a moment. You would be second round. Let me see if there's anybody else first round. Second round.
Have my hand raised, Chairman. Still haven't gotten acknowledged yet.
Go for it.
Thank you. Well, I know that we face some peculiar circumstances in which the mayor has to have the ability to have flexibility to address some critical needs in emergency. I'm in support of that, but I do want to overemphasize that I would like for the mayor to give some clarity on what that is. I want to be supportive of this. Want us to let the executive branch do what they do, but at the same time want to keep our power and doing what we do with the legislative branch. And if she was able to give clarity on this, it would have gave me much more ease. And so if we can, I know Councilman Pinto, you said you reached out to her and asked her for a list that she did not provide. So I don't know what to do now. Just kind of listen in for these amendments to see where we land with this.
Thank you, Councilmember White. I think we're on second round, which means 2 minutes. 2 minutes, whoever's got the clock. Councilmember Robert White.
Thank you, Chairman. I just want to say on this, this is a difficult conversation, I think, for everyone, because I think the council wants to be in cooperation with the mayor for these very real crises. We also want to make sure we're being responsible and not just doing something, but doing the right thing. Unlike COVID-19, which came out of nowhere and was very unprecedented, opioid deaths have been rising for years. Gun violence has been on the rise for years. So to not have a plan forward on COVID-19 makes some sense. To not have a plan on opioids and public safety does not make the same sense to me. So if the council is asking, what powers do you want us to waive, and we will waive them, tell us what your plan is, and we can't get an answer, that strikes me as a problem. So to give a blank check for something that has been a known emergency for years and no plan in front of us strikes me as irresponsible of the council. I think that we have to work in partnership. Partnership goes both ways. That means you can't be out in communities saying the reason that violence is out of control is because of the council. And by the way, council, give me a blank check and I'm not going to respond to your inquiries on what powers you need us to waive. So we have got to be a partner in this government, but being a partner in this government doesn't mean being run over when we need a plan in action. And what the city needs right now is a plan in action. And what the council is saying, I think, is that we're ready to be part of that plan in action. We just need to know what it is. Thank you, Chairman.
Thank you, Councilmember. There's no further discussion. The vote will be on Councilmember Pinto's amendment number 1, which is striking lines 43 through 49. By voice vote, all those in favor of the
Mr.
amendment,
Chairman, can we have a roll call vote, please?
Madam Secretary, would you call the roll?
Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
No.
Councilmember Robert White votes no. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
No.
Councilmember Allen votes no. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
No.
Councilmember Fruman votes no. Councilmember Gray.
No.
Councilmember Gray votes no. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
No.
Councilmember Lewis George votes no. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
No.
Chairman Mendelson votes no. Councilmember Nadeau.
No.
Councilmember Nadeau votes no. Councilmember Parker.
No.
Councilmember Parker votes no. Mr. Chairman, there are 5 yeses and 8 nos.
Thank you, Madam Secretary. The amendment fails. Councilmember Pinto, you had an oral amendment?
Yes, I do. It's just a minor technical amendment for line 51 of the bill, which is like to strike the word paragraph and insert the word subsection in its place.
That's like a drafting comment or amendment. Does that work? General Counsel is nodding her head energetically. If there's no objection, the amendment will be accepted. Hearing no objection, the amendment's accepted. Are there any other amendments?
Mr. Chairman.
Councilmember Robert White?
Thank you, Chairman. I think as we've heard repeatedly, there's no question. We are in a public safety emergency and an opioid emergency. Every week, I have conversations with families, residents, and businesses about the safety of our city. Opioid and fentanyl-related deaths are at a crisis level. The increase in violence in our city has cut so many lives short, several of them kids, and created fear among residents. I know many of us saw the news report with a young child in 3rd grade, not much older than my own daughters, telling the reporter, "I don't want to die." These issues demand immediate and urgent attention. The council and mayor must use every tool at our disposal to stop opioid-related deaths and improve safety in our city. The mayor's order and this emergency legislation are tools that grant the mayor emergency powers to respond to these real emergencies. And like all tools, they must be wielded carefully. A declaration of public emergency provides the mayor with broad authority to respond to an emergency in emergency situations and is only used in extraordinary circumstances. It is council's responsibility to exercise strong oversight, given the number of laws that we waive with emergency powers, even when they are limited, when the mayor requests emergency powers. I appreciate changes my colleagues made to the legislation and to include transparency requirements and oversee emergency procurements. These provisions will help us avoid the concerning procurement practices that occurred during the COVID-19 pandemic, where the Office of the Inspector General found instances of misuse of funds, overspending, and increased risk of fraud. During much of the COVID-19 pandemic, council extended emergency authority for only 3 months at a time. During that time, we noticed these problems with procurements. And the next time the council needed to extend the mayor's emergency powers, we required her to tell us what they were buying before they used district funds to buy it. That's the council's responsibility. We did not stop extending the power, but we did exercise our authority to make sure these emergency powers are used to protect and benefit district residents. I'm glad to see the transparency provisions in this emergency legislation, but the legislation extends these emergency powers to the mayor for more than 4 months. That's over 4 months of expansive authority without enough checks from the council. We're giving the mayor essentially a blank check, and with this legislation waiving the law and much of the council's oversight, we're doing it again, as I said earlier, without a plan. As I mentioned before, without this extension, the mayor must get approval from the council to extend the emergency every 15 days. There's a reason for this. The 15-day timeline ensures that council actively provides oversight and review of the request and continued need for extraordinary powers. If this is indeed an urgent situation that demands these extraordinary powers, then the mayor should be able to ramp up procurement, enhance data sharing, and improve DYRS operations to meet the requirements in the mayor's order within a more urgent time period. To be clear, much of what the mayor says she will do in the mayor's order do not need emergency powers. She could have been procuring beds for DYRS in July when the Youth Services Center was already at capacity and when she asked us to change the law so more youth would be detained pre-trial at YSC, or when she began enforcing curfew for youth, which brought more kids to YSC. She didn't do that. And now we're here with a real crisis on our hands. Providing the mayor with a similar extension as we provided during the COVID-19 pandemic will give the council an opportunity to review the ongoing need for emergency powers to enact requirements identified in the mayor's order. I am proposing that we extend those powers through February 15th. That gives the mayor almost 90 days. After that time, if we believe the mayor still needs emergency powers, she can request to extend it and we can act to extend it. If I could have 15 more seconds, Chairman, to explain one aspect.
30 seconds without objection.
Thank you, Chairman. The amendment that I circulated earlier today would extend the powers through January 31st. I believe that February 15th is a more appropriate time period, given the fact that it will allow the mayor more time to act and will come after the council's February legislative meeting. So I circulated an amendment with a January 31st date. I would like to orally amend that amendment to change the date to February 15th.
Thank you. So the amendment that's before us, I believe it's line 40 of the bill. It is that paragraph or subsection C-1, paragraph 1. Instead of March 31st, it will say February 15th, 2024. Discussion.
Mr. Chairman.
Councilmember Henderson.
Mr. Chairman, I spoke to Councilmember White about this. I think one of the trouble spots of having a legislation on public emergency about two separate different issues is that sometimes we focus on one without thinking about the other, or the issues of one gets conflated with the other. I definitely understand where Councilmember White is coming from in terms of the procurement of additional shelter beds as it pertains to the juvenile crime piece. However, on the opioid side, part of the public emergency and part of the flexibility in terms of procurement powers was in sort of related to the work of the Opioid Abatement Settlement Commission, of which I represent the council and sitting on that body. As a dust-off reminder, because all of you voted for this 21-person body who decides on how the district makes recommendations on how the district is to expend the funds, which I believe we'll be receiving upwards of 80 million over the next few years. We currently have 14 million now. The next Opioid Abatement Settlement Commission meeting is on November 29th. And I'm telling you from sitting through these first two meetings, both of which were 2 hours, 3 hours in length, both times, the commission is not going to have funding recommendations by February 15th. We are hoping for notice of funding availability being made available in January, but by setting the date at February 15th, we will most certainly be coming back to the council for an extension of this public emergency. March 31st seemed like a more reasonable timeline in order for us to complete the work for the first round of funding. So I'm not going to be supporting this just in terms of, I know from the practicality of it, at least on the opioid side, while on the juvenile justice side, they may be able to complete their work in terms of the procurement side on that. It will not be done on the opioid side by February 15th, especially given when you add in the holidays, we're talking about maybe 7 weeks here to do all the things.
Thank you, Councilmember Henderson. I'm going to speak for a second. I'm going to support the amendment. I would urge colleagues to do it. This is exactly what we did with the public health emergency for 2 years, was that we extended it on a short-term basis over and over and over again. And I think that's completely appropriate. We, with the emergency, give the mayor authority to do things that she would not otherwise be able to do as easily. And would have to ordinarily go through more review. So I think it absolutely makes sense that we meet on February 6th. I believe it's February 6th. And we will take up an extension then, assuming that everything is going right. I think you, Councilmember Henderson, are correct that procurements are not going to be done by February 6th, but I dare say that's true on the opioid side as well as on the juvenile justice side. They're not going to be done by February 6th. They're not going to be done by March 31st. And these crises will probably go on for longer. So I recommend that we do exactly what we did with the COVID emergencies, which was that they were extensions were constantly given, continuously given on a short-term basis, and enables us to refine the authority. Maybe we'll even have a list of laws to be waived, and we can give the mayor more flexibility if we take this up on February 6th. Councilmember Fruman.
Thank you very much, Chairman Mendelson. I'm going to support this amendment, but I want to say that I don't think we need to wait till February 6th. I think if the mayor, we need to work together. We need to work together with the administration. And if the mayor comes forward with a list of the laws that she wants to see waived, and on December 5th, we can revisit this. If we have that specificity, I'd be more than happy to extend the date further out, but let's work together on this and let's get that specificity so everybody is doing their jobs and being responsible. We all urgently want to address these things. The call for an emergency came from the council. It's not that we're in opposition to taking dramatic action in order to address these issues. We want to do that, but we need to do it in partnership. They need to do it in partnership. 2 weeks, 10 days after the Thanksgiving holiday to come up with that list is not, there's no reason they shouldn't be able to do that. And if they can work with us, we can work with them, and I could support a longer date. Thank you.
Thank you, Councilmember Fruman. Further discussion? We have the amendment before us. The date was February 15th. Is that correct, Councilmember White?
Correct, Chairman.
All those in favor of the resolution say aye.
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 No.
No.
Let's do the no's when I ask for them. I'll start over again. All those in favor say aye.
Aye.
All those opposed say no.
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 The ayes have it.
No.
Really? Say what?
Mr. Chairman, did you hear that clearly? Could we do a roll call vote?
The roll call has to be asked for before I announce the result.
I didn't hear a result.
I said, the ayes have it, and then I heard an exclamation to my left. All right, we have the bill as amended before us. Further discussion? We'll do a voice vote on the bill. Since the declaration was approved unanimously, a voice vote on Bill 25-579 as amended. And if I remember correctly, Councilmember Pinto had an oral amendment and Councilmember White had an amendment. On the bill as amended, all those in favor say aye. Aye.
Aye.
Opposed? I don't see or hear any no votes. The ayes have it unanimously. The next measure is PR 25-535, Office of Independent Juvenile Justice Facilities Oversight Establishment Emergency Declaration Resolution of 2023. Councilmember Trayon White.
One second, Chairman. Trying to get to a quiet place. Thank you, Chairman. This emergency legislation was written to guarantee that the Office of Independent Justice and Justice Facilities Oversight, Juvenile Justice Facilities Oversight will remain open for the remainder of this fiscal year. It specifies that this office will sunset as initially planned, but the office will have access to the budget allocated to them by the council and the authority necessary to continue its work. The Department of Youth Rehabilitation Services is at a critical point. Facilities are at close capacity. There has been numerous safety incidents. We recently confirmed a new director with a mandate to urgently fill many vacancies, and we expect that the demand on the facility will increase in the near future. Much of the success we've had in the decade of the Jury M is at stake, and the Facilities Oversight Office is one of the best tools we have to monitor these conditions and respond in real time. This is not the time for less transparency and accountability. In fact, it's time for more transparency and accountability, especially involving information regarding our safety of our youth in the facility. My current understanding is that as of yesterday, the mayor has changed the course of plans to continue the operation of this fiscal year. I elected not to withdraw this legislation to alleviate any unnecessary around this office. Sorry. I want to thank council members Allen, Henderson, and Parker for co-introducing this measure. Well, I ask my colleagues to support. B 25-580 amendment. Thank you, Chairman. This amendment mirrors the temporary version of the emergency measures of the Facilities Oversight Bill and will continue the operation of the facility from March 2024 until October 2024. Thank you.
Thank you, Councilmember White. So what we have before us is PR 25-535. And because a lot of paper's been flying, I want to clarify that what we are, and this is a question, I think, either to the council secretary or general counsel. What we have before us is what was filed and is linked on the agenda, correct? There are no amendments to it.
That's right, to the deck.
With regard to the deck,
Right, yeah, that's as far as I know.
Madam Secretary, what we have, but there are no amendments on the declaration. Okay, and Councilmember White has moved it. So we have PR 25-535 before us. Is there any discussion? Roll call vote on the declaration.
I have a question.
Hold on the roll call.
Okay.
Yes, Mr. McDuffie.
We're on the deck, but I want to just make sure I understand practically how this emergency would take effect or would be otherwise triggered. If somebody could explain that, would be helpful.
I'll take a stab at it, and then Councilmember White, correct me if I get any of it wrong. When the council adopted the budget for fiscal year 24, which is what we're in, the council included funding for this office. A few weeks ago, the mayor issued a mayor's order that said that this office would close in January. This legislation would override that mayor's order. Although what it does is it says if there is an effort to abolish the office or close the office, then the Emergency Act takes effect. The mayor issued a mayor's order yesterday extending the office. The mayor could issue another order. I don't think that's likely, but she could issue another order. And if she did, then the terms of this bill would say that the office would continue. I think what this bill actually does is establish the office. So it's at this point, it's what I would call a safeguard that may not be needed. But if there was another mayor's order that changed, revised what was issued yesterday, just because there was a mayor's order a couple weeks ago that revised what we did in the budget, then this bill would have effect. Does that answer your question?
It's helpful. Just if you could point me to what paragraph you're referencing, that would.
I think it's section 2.
Somebody said section 2, line 25.
On the sunset.
So a couple of things would have to happen. Because I'm not sure if you mentioned it, but after the mayor issued an executive order that would have closed the office, she issued a subsequent executive order
To open the office,
to open the office.
well, or to extend the office, or to repeal the sunset.
So there would have to be two things done. She would have to issue 2 additional executive orders
Just one.
that both repeal the existing one, but also sunsetting the office again.
You only have to do one mayor's order. I don't want to speculate too much on this because I'm hopeful that with yesterday's mayor's order that this will no longer be necessary.
Okay, but that's why it doesn't have, there's not a fiscal impact, because this would only take effect if the office were sunsetted within this current fiscal year.
Correct, during the duration of the emergency or the temporary,
Got
which would be within this fiscal year,
Got it.
and it's funded through this fiscal year in the DYR's budget.
Okay.
Clarity on that.
Trayon White.
Yes, thank you. To answer in short, this office was already funded. I tried to get some clarity last week about the mayor's desire to keep open or close this office, which I was unclear, which I spoke to the mayor, spoke to other members, and it was a conflict on where we were going to land. And then I actually spoke to the director of the agency, which confirmed that he was giving orders to start shutting down, which we already funded. And like I said, this is not the time to remove any transparency or accountability for this agency. And so we drafted this and with my colleagues to ensure that we can keep this up. And so the mayor then issued this yesterday. So we want to ensure that in the spirit of being a good partner, that we can both support this, because it sounds like it's 2 different messages conflicting between last week and this week from the executive, and we want to be ensured that we are doing our part as a legislative branch to keep this office open.
Councilman McDuffie, you good for the moment?
I am good for the moment. Thank you.
Okay. Is there further with regard to the declaration? I said that with hesitancy. We haven't voted on the declaration yet, correct? That's right. I was about to. I'll ask for the roll. All right, the measure before us is PR 25-535, the declaration, roll call vote.
Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill. Councilmember White,
So moved.
and I'm assuming, Councilmember, that you are also moving the amendment nature of a substitute.
Yes, sir.
All right, we have the amendment nature of a substitute before us. It was circulated yesterday. Actually. And it's also linked to the agenda. If there's no objection.
Now is not a good time. Sorry.
Maybe it's a good time.
All right, so we have before us, I'm not quite sure what to say here. We have before us the amendment nature of a substitute. If there's no objection, the amendment nature of a substitute will be accepted. Hearing no objection, it is accepted. So we have the bill as amended before us. Is there discussion?
Mr. Chair.
Councilmember Allen.
Thank you very much. First, I want to thank my colleague, Councilmember Trayon White, and our co-introducers for moving this emergency legislation forward today. As has been mentioned during our discussion of the prior emergency, we consider the district is experiencing an increase in violent crime, including deeply concerning trends among young people. As most of us know here, DYRS came out of a more than 30 years long consent decree and litigation regarding conditions and services at DYRS facilities. The mayor, as part of the settlement agreement in that case, created the Office of Independent Juvenile Justice and Facilities Oversight to ensure durability and promote the expansion of achievements under the consent decree. And the executive has worked very hard to improve conditions at DYRS facilities. As we consider legislation and strategies to combat violent crime and reverse the trends that we've seen, especially with young people in particular, it's important that the services we're providing to young people who are in DYRS facilities are adequate and appropriate, and we maintain the current level of services that we achieved under that consent decree. Both accountability and rehabilitation depend on that. My colleague, Councilmember Trayon White, has spoken about his visits to DYRS facilities and highlighted staffing challenges as well as safety incidents currently affecting the agency. The Office on Independent Juvenile Justice and Facilities Oversight monitors and provides reports and serves as an important oversight role. In general, because of their important duties, public safety agencies often require rigorous oversight. We currently have such a system, for example, with the Department of Corrections and the Corrections Information Council, and it should be no different here. While this emergency ensures the office operates until the end of the fiscal year, we know that we're going to need to consider whether the office should continue to exist beyond the current fiscal year. Transparency, oversight, and sunshine is crucial. I know that Councilmember Trayon White's working on permanent legislation that would address that, and I look forward to considering the legislation when that's introduced. Mr. Chairman, I have been made aware by council we need to move an oral amendment to the ANS, though, that was just accepted. The mayor's order named the office as the Office of Independent Juvenile Justice and Facilities Oversight. So I hope Councilmember Trayon White can accept as friendly, just simply adding the word oversight each time the full name of the office appears. That would be the long title on line 18, the name of the legislation on line 23, and lines 26 and 28 of the ANS that was circulated at 414.
Is that an oral amendment?
Yes, if I'm hoping that
it?
would be accepted as friendly, but simply to just make sure we add the word oversight at each time when the full name of the office appears. So that would be in the long title on line 18, the name of the legislation on line 23, and lines 26 and 28 of the ANS.
So that the name is the Office of Independent Juvenile
Justice and Facilities Oversight.
Yep.
Okay. General Counsel, you're clear on that?
Yes.
I accept this friendly too, Chairman.
All right, if there's no objection, that it's almost like a technical amendment is accepted. Further discussion? Left us all speechless, Councilmember. We have the bill as amended. That is the amendment nature of a substitute, which was accepted, and Councilmember Allen noting the correct title to be amended throughout, which was accepted. I think we can do a voice vote on this since the declaration was unanimous. All those in favor of the bill as amended, say aye.
Aye.
Aye. Aye.
Are there any opposed? I don't hear any opposed. The bill as amended is approved unanimously. That gets us to first reading and vote on temporary legislation. We have Bill 25-580, Opioid Crisis and Juvenile Crime Public Emergencies Extension Authorization Temporary Amendment Act 2023. Councilmember Henderson. Oh, I'm sorry. Why did I call on you? Opioid. Councilmember Pinto.
So moved.
We have the temporary bill in front of us. Councilmember Trayon White, did you have an amendment?
No.
Yes. Councilmember Trayon White, in your, when you,
580?
yes, yes.
Okay, I'm sorry. Yes, this amendment mirrors the temporary version of the emergency measures of the facilities oversight bill. It will continue to operate the facility from March 2024 into October 24 if this also was sunset during the fiscal year as initially planned.
All right, so let's be clear so that all the members understand and the record is clear. Councilmember Trayon White is moving an amendment to Bill 25-580. Bill 25-580 is a temporary for the opioid crisis and juvenile crime public emergency extension. Councilmember's amendment is the temporary version of the Office of Independent Juvenile Justice Facilities Oversight Establishment. To be clear, and I need the general counsel's attention, to be clear, the temporary will reflect the amendments to the emergency,
Including oversight in the title.
including oversight in the title, including the amendment nature of a substitute, including all the amendments to Bill 25-575. Does anybody have a question? What's happening here?
Mr. Chairman,
Councilmember Pinto.
I will need to move a corresponding oral amendment the same as I did on the emergency for line 51 to exchange the word paragraph and instead put in its place subsection.
Well, yes, except that, and I should have said this, the temporary for both bills will be the same, will reflect the amendments to the emergencies. So there were two amendments to the opioid crisis and juvenile crime public emergencies extension, and there were two amendments to the Office of Independent Juvenile Justice Facilities Oversight Establishment Emergency. So I'm going to check with General Counsel. The temporary, there's an amendment pending right now, and the amendment is to add the Office of Independent Juvenile Justice Facilities Oversight to the opioid crisis and juvenile crime public emergencies extension authorization. Two temporaries are going to be in one bill, and the two temporaries are going to reflect all the amendments that were made to the emergencies. General Counsel, is that clear?
Yes, it is, Mr. Chairman.
Is anyone on the council confused? I heard a no or a yes. All right. I think we can do this by a voice vote, unless there's discussion. By a voice vote, Bill 25-580, actually, I did not see this. Councilmember Trayon White's amendment is accepted without objection. Hearing no objection, so it's part of the bill. The bill is amended. Bill 25-580 is amended. All those in favor say aye. Aye.
Aye.
Aye.
Opposed? The ayes have it unanimously. That was a lot of work. If there's no other business, the next meeting of the Council of the District of Columbia is December 5th, 2023 at noon. I am told to say to everyone, happy Thanksgiving. The committee of the whole, you all are invited. The committee of the whole has a hearing, I believe, at 2:00 today. And we usually do it in 4:12. 2:15, no, 2:10. That means I have to hurry. It's 1:44 PM and this meeting is adjourned.